The second you get into court, you've lost. Because the minute you're getting into court, the legal bills are going up and up and up and up. And suddenly you're in a government bureaucratic process. Hi, Jeff Mersace, the Plain English Attorney, and welcome to the video. Today we're going to talk about a hot topic, and I keep getting questions about this. Hey, can't we just remotely sign our estate planning documents? No! In addition to it not being proper or even legal, it is a bad idea, and we're going to run through the 5 biggest reasons and maybe even throw in a couple of bonus ones to say why this is a bad idea and why, at least the way technology is right now, you do not want to have estate planning documents be digitally signed and especially not digitally notarized. All right, so let's go ahead and jump right into it. The first reason, it's probably not even legal in your state. Now, I'm going to give the caveat here. All I did was check North Carolina, and I went through the rules and what can actually be notarized and done digitally or remotely. And the fact is, you can't sign most estate planning documents. All right, so here's a list from a law firm. They're quoting from the Secretary of State, just giving a couple of answers. All right, so there's a self-proved will is not allowed to be executed. A revocable or irrevocable trust is not allowed to be done remotely. A death beneficiary form that, quote, requires an acknowledgement, which means, okay, it's notarized. If it has to be notarized, it can't be done and signed remotely. So this even means things like IRAs and 401ks. Oh, I'm going to change the beneficiary. I'm going to just do it remotely, but it has to be notarized? Nope, sorry. Not allowed under the law in North Carolina. Codicils to wills, well, okay, it's the same formalities as a will, so that also cannot be done remotely. And also any document that is relinquishing parental rights or requires some kind of notarization from absentee mail-in ballots. So all of those are just completely off the table to begin with under law. Well, okay, if we're going to be doing a signing for our clients, even if it's the simple will, the big 5 documents, well, already right off the bat, you can't sign the will remotely. So if you got to come in person and have it signed, ink on paper in front of 2 witnesses and a notary, well, then we're going to do all of the other documents in addition to that. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. All right, so second big reason, if the notary is not in the presence of everybody, then they can't really acknowledge that it was actually those people. So yeah, here's exactly how the electronic notarization of any kind of document works. It's like, okay, it's an electronic document and maybe there's another party, but they have to be there in person with the notary so that they can check the identification and actually apply the electronic notarization. They got to check and make sure all of the processes and procedures are done for that person who's signing. So, all right, we get it if there are people in 4 different locations, but each one of them has to have a notarization in person as part of this whole remote process. So again, with estate planning, most documents requiring at least 2 witnesses and a notary, there's this in-person element anyway. So no, you are definitely not going to get to stay home in your pajamas and sign your legal documents. Just can't work that way. All right. What about the third one? This is where we're going to start to get into what's coming down the road. And this is the reason why I never even really wanted to look at this in the first place. I wanted to keep it live. It's because the questions are going to come up, not now, not next year, but 5, 10, 15, 20 years later when the documents are actually kicking in. Here are all of these questions that are going to start coming out. And that third one is, well, were the witnesses really there and see everything? Did they actually see the signature happening if they weren't in their presence? Well, okay, they're probably not going to remember, and it's not ink on paper. If the witnesses are not in the same room as the person signing the document, how do they know that that was what they were signing? They don't know. And that's a problem that's going to come up if the estate plan is going to get attacked down the road. All right. So that can be a big thing. The witnesses aren't even in the room. Is anybody off camera trying to influence what's going on? That's another big thing. If you're sitting in an office like we have with our conference room and all the documents are all laid out and the people are sitting there and we sign the documents and we go in turn, okay, you're signing the document, if there's a spouse, they're signing that document or their own documents. It goes over to the witnesses. It's two witnesses, we've got two witnesses and a notary, and we've got the clients there. If somebody's off to the side and going, Mom, just sign it. Just sign the document. It's okay. Oh yeah, you're signing your lunch order. You can't say for 100% certain that if it's a camera just focused on the person, that there isn't somebody off camera trying to influence them. And this is where the questions are kind of going to come into play. Attorneys are going to get hired to attack the plan. And this is one of the things that's going to pop up is, was there anybody in there actually influencing you? They can't do that without the witnesses and the notary in the room seeing what's going to happen. So that's just another reason why we're not going to handle this stuff digitally, because we don't want these questions popping up down the road. All right. What is the fifth reason? Can anyone actually confirm that the person was of sound mind when they were in the room without live seeing their mannerisms, how they're reacting to things? There's this whole thing in the presence of someone where you can just tell something's wrong, something's off. You can't get 100% of that through a camera. And so that's one of the reasons why I suspect that the legislature said, yeah, sure, okay, we're going to do remote signings for things, but we're going to exempt this. Well, all right. Why? Why are we exempting these particular types of estate planning documents, such as wills, codicils, trusts, and irrevocable trusts? Well, there are three big reasons why, and I'm sure there are more, and this is also a good time. Look, if you can think of any other reasons why this would just be a bad idea, please go ahead and put it into the comments, because this question comes up all the time, and one of the things I'm planning on doing is using this video anytime someone says, well, I don't see why we can't do this remotely. No, this video is going to be right there front and center so that they can see all the reasons. We want to guarantee that if for some reason your estate plan is going to be attacked, it's not going to be because it wasn't properly done, signed, witnessed, and notarized, and there were people in the room who can attest that you were of sound mind at that point. So all those questions get eliminated off the top, and those are some of the biggest reasons people will try to attack something. So in the formalities, let's at least make sure that's correct. We hear this all the time. Well, we can do this for these documents. Why can't we do it for estate planning? One, when it comes to things like contracts, mortgages, other things, you're executing those documents and you're starting to fulfill the duties that are listed under them. Okay, you sign a mortgage remotely, if that's even allowed. You start paying that next month. It's not like it's going to be 15 years before you're making a payment. No, the payments are starting right away. So it becomes very difficult to try to attack it. Oh, this didn't really happen. Well, then counselor, why did they make those payments for 15 years and you're only attacking it now? You're saying it was fraudulently signed, but yet they still kept paying for 15 years. It doesn't make any sense. Okay, these other documents, it's allowed. Okay, no problem. It's because they don't require witnesses. Or if it is a witness, if it's something like, okay, you're signing an application for life insurance or an annuity, and this happens all the time. There are companies that will go ahead and do this, and the witness is the agent who's actually taking down the application and putting it in place. And yes, they signed it in front of me, and now it's fine. There's also typically some kind of confirmation that comes back, and it's okay. It's not just a one-time thing. The application may be sent in, but the final paperwork may be an ink signature accepting it. So it's got to be something that's also done live. All right, so there's that signature. So, and these things aren't comprising everything a person owns, and that's the third thing. When it comes to estate planning, you're trying to do this digitally. It's for everything you own. I mean, we can be talking about hundreds of thousands or millions and millions of dollars into a document that may not be needed for 10 to 15, 20, 30 years down the road, where all of this stuff can be attacked. So these are the reasons why estate planning documents are different and why it could lead to a potential disaster. So this is also something that I hear from attorneys all the time. Well, okay, if you keep the records and you can show, well, look, this is what they were talking about and whatever. The second you get into court, you've lost. Because the minute you're getting into court, the legal bills are going up and up and up and up. And suddenly you're in a government bureaucratic process, whereas with things like revocable trusts, we're trying to avoid all of that with estate planning. So why would you even want to have a process where that even becomes a possibility? So my law firm, for the time being at least, there's going to have to be some huge technological advances, not to mention a change in the law allowing this. We're going to stick with the in-person signings, ink on paper, notarized, done and taken care of, so that we have that ink on paper original. One set of originals for us, one set of originals for the clients, no question. Even during the height of the lockdowns, when we were still either meeting with clients or meeting remotely, attorneys were exempt from a lot of those lockdowns. When we were doing the signings, we would go out into the parking lot, lay out a table, have the documents, everybody wearing masks and gloves and wiping everything down. We'd have those ink on paper signatures, move the whole table. The witnesses from my office would sign. Everybody would see everything. We'd be in each other's presence, even though it was in a parking lot. And then, as extra precaution, we'd take the documents. They'd be in a bag. I'd have them pop the trunk or open the hatchback, put it in and say, look, just leave it there for 5 days. And that was it. So we found a way, even in the height of the lockdowns and all the restrictions, to make this happen with ink on paper, with live witnesses and notarization. Let's not call stuff into question just because you would prefer not to make the trip. Even if it's, you have to come in from out of state, or we have to delay the signing until you're back from out of state. It just makes safety sense. Let's make sure that we're getting this done correctly, and that does mean live in-person signings. All right, so I hope you found that information useful. As I always tell my clients, please stay safe, plan ahead, and enjoy life, and whatever you do, make it a great day.